Welcome to the presentation that will be covering Title VII. Title VII is the single most important statute that we will be learning about over the course of this semester. So we're going to spend a fair amount of time, obviously this chapter about it, but we've also, as you've probably noticed, covered it in previous lectures, and we will talk about it in future lectures. So it's not going away, but this is the presentation that is going to focus exclusively on this particular statute, or virtually exclusively on this particular statute. So this kind of gives us an overview of where we're going for this particular presentation. We're going to learn about a little history, how we got to have Title VII and kind of what happened after Title VII, so we can have it in a context. And then we'll talk about what employment discrimination is about, the categories of employment discrimination. You may recall in previous lectures that we talked about the various theories of recovery. As you can see here, disparate treatment, disparate impact, which for some reason is called adverse impact here, and retaliation. So let's get started. As you know, in these presentations, I put some of the material in italics. Those are my notes, actually, to help me remember what I really wanted to emphasize. As you're taking notes during the class and you're looking at your study guide or you're looking at the PowerPoints, that may be material that you want to also put into bold or to highlight or something along those lines. Another thing I like to remind students about is that I'm going to kind of dive into the details. I'm not going to give you a lot of big picture stuff. So really, please, if you haven't already, read the chapter, read up whatever material that I've assigned relating to this particular portion of the class so that you'll have a big picture sense as to what's going on. Have those categories of data, and you can get that from the PowerPoint and from the study guide, and then you'll be prepared to kind of drill into the specifics that I'm going to do during this lecture. Okay, so the history of civil rights in the United States obviously is very long and very gruesome at times and very sad at times. We're not going to obviously talk about the Civil War and all that kind of stuff. That's beyond the scope of this class. But there are 3 statutes that came down right after the Civil War. Many times they're called Reconstruction era statutes that we call Section 1981, Section 1983, and Section 1985. Section 1981 is the main one that we're going to talk about in this class, but these are 3 important statutes. Now, they have changed over time. They aren't the same version that became law in 1866. There have been changes and additions to it, but that is the genesis, the beginning point of the statute. Anyway, they prohibited discrimination based upon race in the making of contracts. That was the first one, 1981. And they also prohibited anyone in a governmental position discriminating, not just specifically about certain types of discrimination relating to race. That's Section 1983. And then they finally prohibit concerted activity to deny someone of his or her rights relating to race, and that's Section 1985. Much of this had to do with organized activity like Ku Klux Klan activities, things along those lines. So these are 3 very important statutes, both historically and in relationship to current law, especially for our purposes, Section 1981. You see a phrase here for Section 1985 that I'd like to draw your attention to, and that is color of law. That's kind of a strange expression, and maybe one that you're not very familiar with. So I wanted to give a little bit of clarity about it. When somebody acts under color of law, they are a government person who is saying, I can do this because the law has given me this authority. Now, many times when people act under color of law, they have the legal right to do so. So let's say I'm a police officer and I issue you a ticket because you were driving 45 miles an hour in a zone that was posted for 35 miles an hour. Well, I'm acting under color of law when I do that, and I'm doing my job. I didn't do anything wrong by doing so. But let's imagine that actually you were driving 34 miles an hour, and I cite you as if you were going 45. Well, I am still attempting to act under color of the law, but guess what? I am violating the law. I actually don't have the authority that I claim that I'm having. And so in this context, we would say a government entity is illegally discriminating against another person during the performance of his or her official duties. But really the important part here is under color of law is when a person is performing his or her official duties. So it doesn't just apply to illegal discrimination. And again, a person's acting under color of law when they're completely behaving themselves. So this really isn't a very good definition, but it's one that I have seen in other contexts, and so I was going to go ahead and keep it because I think that that may help with other materials that you're going to be exposed to. Obviously, when you are illegally discriminating, that behavior is prohibited. Okay, so we've talked about 1981, Section 1981. Again, it allows a victim of racial discrimination to claim unlimited damages from the defendant. We'll talk about this later. Actually, we talked about this in the last chapter. This is really important. This is the part that I want to draw attention for you to, is the idea of unlimited damages. Under Title VII, a successful racial discrimination plaintiff can get damages, but there are definitely limitations. It's not, you're not going to get millions of dollars out of a Title VII claim, but out of a Section 1981 claim, that is a possibility. And so this is an interesting feature of this law, and it's one of the reasons why plaintiffs' attorneys oftentimes will sue under Title VII and Section 1981. Now, of course, Title VII covers a lot of categories other than race. Section 1981, again, because of the history, post-Civil War statute, that's focused upon racial issues. So if I'm, say, a sex discrimination plaintiff, I'm not going to have a claim under Section 1981. We already talked about Section 1983, but just a little reminder, state action, in other words, someone from the government, the state government can't deprive somebody of their civil rights, especially relating to race. Obviously, because state action is required, a Section 1983 claim won't work against a private employer. Let's consider this particular scenario just to give you a flavor for it. So Mary is Asian. She is a social worker, and she works for a state governmental agency. So she, so any action that happens to her in her capacity as an employee of that agency would qualify as state action. She's denied a promotion even though she did well on the test. A white coworker who scored less well is promoted. Mary appeals, but she's not successful. She believes she was denied a promotion because of her race. So therefore, she would be able to bring a discrimination claim under Section 1983. If we change the facts and make her employer, say, a private adoption agency, then she would, instead of suing under Section 1983, she would sue under Section 1981. Okay, so let's put a little bit of perspective. We've talked about things right after the Civil War, but that was a really, really long time ago. And obviously a lot of things happened between the 1860s and the 1960s. But we're going to put that kind of in the history courses that you might be taking, and we're going to focus on what's happening in the 1960s. In the late 1950s, actually not just late 1950s, but in the 50s and 60s, there was definitely a growing civil rights movement. Brown versus Board of Education had become law. Sweatt versus the University of Texas had been decided. The Central High in Little Rock, Arkansas had been desegregated. So there were definitely changes afoot. But many of these changes were very, very controversial and were opposed by significant portions of the population. JFK was president, obviously, in the early 1960s, and he was working hard to pass a kind of a complete civil rights package that was going to be called Civil Rights Act to address some of the concerns that were being advanced. Obviously, he passed away in November of 1963, but when Lyndon Baines Johnson became president after the president's passing, he President Johnson continued the efforts to pass the Civil Rights Act. And so in 1964, it did become the law of the United States. Obviously, it was a very controversial law. It had many, many different aspects. We focused just on the 7th title, which is typically called Title VII, and it's usually written with a Roman numeral. But obviously, there were other sections to it that covered other aspects of life in the United States. A concern that existed at that time was this a constitutional exercise of power by the Congress? At that time, the understanding that existed in the law about the scope of the Commerce Clause in the United States Constitution was more narrow than it is today. And so there was a legitimate question about whether Congress had the authority to tell private employers that they could not discriminate in the selection and retention of employees. And here's the language from that Interstate Commerce Clause. It says, Congress can regulate commerce with foreign nations and among the several states and with the Indian tribes. So the question is, when Congress passed this law, was it regulating commerce among the several states? Was that scope of that power represented in this clause enough? Was it sufficient to allow it to pass Title VII? Actually, not just Title VII, but the whole Civil Rights Act of 1964. And there was a genuine uncertainty about what the result of that would be. It ended up that the Supreme Court held that yes, that was not an unconstitutional exercise of power of the Congress, and that was one more step in the broadening of this Commerce Clause power. When Congress acts with respect to the economy, most of the time it is exercising its authority under the Interstate Commerce Clause. In this clause of the Constitution is actually the primary source of federal regulatory power today. If we were to go back in time 100 years to the early 1900s, definitely the understanding of what the Commerce Clause scope was so much more narrow, no one would have thought that the federal government would have the right to do any of these things. They would have agreed that each state would have had the right to do that. So no one would have said, well, the state of Texas can't pass the Civil Rights Act of 1964, or Wyoming can't pass the Civil Rights Act of 1964. But the understanding of the proper role of the federal government versus the state government was just fundamentally different 100 years ago. And even in the early 1960s it was less certain how that case would be handled. And so that's a difference, a development in the law from where we are today. As I said before, the Civil Rights Act of 1964 developed out of the civil rights movement that people like Martin Luther King and others had begun. And so the focus of it was on race. Again, there was a history of pretty extreme racism in many, many parts of the country, certainly in the South, but also, frankly, throughout the United States. There were Jim Crow laws, there was segregation. Some of it was legal segregation, meaning the law actually prohibited certain levels of mixing of the different individuals and different communities. And some of it was de facto. Yeah, there might not have been a law, but everybody knew if that person of that race goes into this part of town, bad things were going to happen. This system is oftentimes called Jim Crow, and that's the name for it. It was a system of racial segregation practiced, again, in many, many parts of the country, sometimes by law, but also because of social customs, and many times these ideas were being enforced through violent acts. And we already talked about Brown versus Board of Education. This struck down the idea of separate but equal and led to the integration of public schools. So here is the specific things, not a complete list, but many specific things that the Civil Rights Act of 1964 prohibited. It prohibited discrimination in education, in public accommodations, and in the receipt of federal funds. And of course, the one we're focused on is employment. And let's look at the bases. I said that race was the main focus. That's what people were worked up about, but it wasn't limited to race. It included race, color, gender, national origin, and religion. You definitely need to know these 5 areas, and you need to know they're found in Title VII. So you might want to put a little asterisk here and be sure to be able to recite those. So Title VII is the employment section of the Civil Rights Act of 1964. So let's look at what discrimination is. You can see this term is in red, so you're going to want to pay a little bit more attention to this section. What is discrimination in the context of employment? It's a limitation or denial of an employment opportunity based upon a protected class characteristics of a person. And I think it's important to pause and to consider that we discriminate all the time. Discrimination is not an inherently bad thing. If I have 2 students in the class and one studies really hard and gets all the answers to the test questions correct, and another student doesn't study and only gets 50% of the questions right, I'm going to discriminate against the one that got only 50% right and fail that student, and then the student who got all the questions right, I'm going to give an A to. That's not unlawful. In fact, that's my job, to discriminate the levels of performance that students have. You as an HR manager or you as a paralegal or an attorney would also be making discriminations. For example, let's say you're a paralegal or an attorney and you have a client come in, or you have a potential client come in and they have really bad facts. They ran a red light and caused an accident, but they want to sue the person they ran into. You're perfectly right to discriminate against that lawsuit and say, we're not interested in taking it. If you're the HR manager and you're hiring somebody, you have one person who has all of the credentials that you want. He or she comes in dressed professionally, behaves appropriately, is enthusiastic, has good answers to questions. His references or her references are just what they ought to be. And then you have somebody else who arrives 30 minutes late, is poorly dressed, is surly, doesn't have the credentials that you would want, references are not good. Under those circumstances, you should discriminate against the one who performed poorly and hire the one who did perform well. So discrimination is not inherently a bad thing, but of course when a person is using discrimination to disadvantage someone for something that does not relate to their performance on the job, that is wrong. It's obviously immoral, but it's, for our purposes, more importantly, perhaps, it's unlawful. And so when we discriminate, when we treat someone adversely because of these characteristics, race, color, gender, national origin, and religion, then we have an example of employment discrimination. And the term that we oftentimes use for this is adverse employment actions. There's lots of them: failure to hire, termination, failure to promote, demotion, not giving a raise, making a reduction in pay, harassment, retaliation. Those types of things could count as segregation of employees based upon the protected characteristic. All of those things can be adverse employment actions. We talked in a previous presentation about the definition of employee. And under the case of the National Labor Relations Act, we discussed how supervisors and managers were not included in the definition of employee. Well, just to be clear, in the employment discrimination statutes, including Title VII, supervisors and managers are included in the definition. So people who supervise others and manage others are entitled to the same protections under Title VII that anybody else is. If a person is a partner, meaning they're a part owner of the business, then usually they won't be covered, but even that's not guaranteed. In certain cases, they can still be covered by Title VII and the other statutes. Okay, so let's dive in more specifically to what Title VII is about. Again, here are the characteristics that we have here. I want to flag this one because this is kind of an interesting story. So when Title VII was being put before the Congress, a Southern senator who generally opposed the statute and opposed the protections for African Americans that was being recommended for the statute, got up and made a moved to make an amendment to the statute to include gender as a characteristic. There had been no discussion about adding gender before then, and he made no comments as to why he was recommending that it be added. The only thing that the transcript from that hearing or from that presentation has is that immediately after he said it, there was laughter. So that's all we know is this Southern senator proposed this language and laughter ensued. And of course, many people think, well, the reason there was this laughter because it seemed like a ridiculous idea. Well, it's one thing to say we can't discriminate against African Americans, or we can't discriminate against people because of their religion, but surely we can discriminate based upon people's gender. Many people think that the reason that the Southern senator wanted to put the gender in is that he wanted to show the ridiculousness of this law, because everyone would agree that gender discrimination is a ridiculous idea, and that would just make the point that the racial discrimination protections were equally ridiculous. Or perhaps the Southern senator wanted to cause this particular amendment to be controversial and to divide the senators so that they couldn't reach one mind about this law, and maybe that action would kill the bill entirely. That's a second theory that some people have. A third theory that some people have is that this senator, though, actually genuinely believed that gender ought to be added as one of the protected characteristics. While he opposed racial discrimination protections, he did have a pretty good record with respect to gender discrimination. He had some staff members who were women, and he seemed genuinely supportive of employment for women. And so it's possible that it was a genuinely sincere action. We just don't know at this point, but it's an interesting story in any event. There are other protections that we have other than race, color, gender, religion, national origin. For example, under other statutes, we have protection from age discrimination, disability discrimination, and then in some states, there are other types of protections such as affinity protection. We'll talk more about that later. But these are under other statutes. In fact, the age discrimination statute is called the Age Discrimination in Employment Act, and the abbreviation for it is ADEA, or oftentimes called ADEA. The Disability Discrimination Act is called Americans with Disabilities Act, and that is ADA. It's usually not pronounced, or just the initials are used. So it's important to know that while we have protections from age discrimination and disability discrimination, they're not part of Title VII. Those are separate statutes, and we'll talk about those in separate presentations. So here are some examples of things that Title VII protects that these are considered potentially adverse actions. So obviously hiring, firing, promoting, demoting, all that could be adverse employment actions. Denying training, giving more discipline, giving better pay to people of a different category or better benefits. Classifying people, maybe certain classifications has more status or more upward trajectory in terms of the hierarchy. And then there can be just so many other things. Segregation, maybe having one break room for this group and another break room for that group, different bathroom facilities, all of those things. But even though it seems very broad, it's not endlessly broad. So for example, most dress code issues the employee loses on. So if an employer chooses to have a dress code that says female employees must wear a skirt or dress and male employees must wear slacks, those have been pretty universally upheld. So it's not that an employer can't make some distinctions, but they can't be kind of at the heart of the employment relationship, and they certainly shouldn't have an economic component. So who must comply? Who is an employer for these purposes? We talked about this in a previous presentation, but let's do a little bit of a refresher. Well, employers have to have at least 15 employees. The actual equation's a little bit more complicated, but for our purposes, let's just think 15 or more. We'll see under Title VII it's 15, but under some statutes it's 20 or 50. You are responsible for knowing what the different levels are. Another category are unions. You might say, well, gosh, a union could have employees. Most do. They're oftentimes called business agents. But unions, and so obviously if a union has employees, then it would be considered an employer. And if it had more than 15 employees, then it would definitely be covered under this category. But unions can discriminate against the people in the workforce who work for that private employer. So imagine that you have an employer, let's say it's ABC Automotive. They make cars and they have 1,000 employees, and a union, will say it's the Teamsters, has organized these workers. Say 500 of the workers are in this unionized facility. None of those workers are employees of the union, but the union is going to be negotiating with the company about the terms and conditions of employment. So let's say the union wanted to say, we don't want any women working in this place, or we don't want any people of that ethnicity or that race working in this place, or we don't want people of that age or that religion. Well, you could see how they could negatively impact and cause discrimination. And so they are prohibited from doing that, just as the employer is prohibited from doing that. Similarly, employment agencies. Sometimes employment agencies actually do employ the individuals who go to work for the clients. Sometimes they're just kind of a go-between, but either way, they can't facilitate or implement any kind of discrimination. And then government entities, really at all levels, federal, state, and local, they can't discriminate against their employees or their applicants. We already said that 15 or more is the standard for the Title VII and the Disabilities Act, and also Texas's discrimination statute. But the age discrimination employment requires 20 employees. You may think to yourself, well, that's kind of random. I mean, why not have them both be 15 or both be 20? I don't know the answer for that. I think it goes back to the idea that when Congress or any legislature is trying to draft a statute, there's a give and take. One side gives a little here in order to get a little there, and that back and forth results sometimes in somewhat surprising results. So for whatever reason, at that particular moment in time, 20 seemed to make sense to our congressmen and women. So there you have it. The Equal Pay Act, which actually was the first statute, and maybe I ought to have covered that. I apologize for not mentioning that before. When I was talking about, Brown versus Board of Education and Sweat and those other cases that happened in the 1950s, the next kind of thing that happened in our trajectory, even before the Civil Rights Act of 1964, was the Equal Pay Act of 1963. This statute was about gender, and it prohibited employers from paying one gender less than another when men and women in that position both did the same work. The jobs have to be pretty darn close to the same type of job, and we'll talk more about this later. So imagine you had a school, and let's say it's an elementary school, and you happen to have 20 teachers in this school. 5 of them are men, 15 of them are women. They all have the same education. We'll say that the school just opened 3 years ago, so they all have the same amount of experience. They were all straight out of teacher school. If that school happened to have paid the men more than the women, just because they were men, then that would be a violation of the Equal Pay Act. Similarly, if the school paid the women more than the men, that would be a violation of the Equal Pay Act. So this law actually predated Title VII by a year. It is a much more narrow statute, both in terms of its remedies and in terms of what particular behavior it protects. The protections afforded under gender under Title VII are significantly broader than the protections that are given for gender under the Equal Pay Act. But you can see how the Equal Pay Act does have one benefit, and that is that it applies to really, really small employers. So if you have been a victim of gender discrimination and it is related to your pay, and your employer doesn't have 15 employees, you could see why this statute might be very useful for you. So it's not without some significance. We'll talk more about this when we get into the gender discrimination chapter. We can see the Family and Medical Leave Act, which is oftentimes called the FMLA, requires even more employees. You have to have at least 50 to be covered. And actually, this is quite a bit even more complicated equation for this. We'll talk in more detail later on. You know, it makes sense because this puts affirmative obligation on employers to return certain employees to work. If you have a very small workforce, losing an employee and not being permitted to replace the employee can cause a lot of headaches for a very small employer. But once you reach 50 employees, it kind of makes sense that you can have workers kind of help out and fill in so that the loss of that temporary loss of one worker should be manageable by the overall workforce. I mean, that's the logic behind this. And then IRCA, which is the Immigration Reform and Control Act, applies once you get that first employee. This is the I-9 statute. It also has some other requirements, and we'll talk more about that as we move forward in the course as well. So let's go on from here. Let's look at a scenario. So Bob is an auto mechanic. He works at an auto shop. There are 20 mechanics in the facility. So you're probably thinking, it's going to be covered by Title VII and ADA, but it's also going to be covered by the Age Discrimination Employment Act, the Equal Pay Act, and also IRCA, but it won't be covered by the FMLA. Okay, so Bob is African American. He's the only one in that particular unit, and he's been employed there for 9 years. He's applied for promotion, but every time a Caucasian man with less experience has been promoted. So Bob finally has had enough of this, and he files a charge of discrimination. He's fired after he files this charge. So under those circumstances, the owner of the business, Larry, can be found liable for discrimination under Title VII because, again, more than 15 employees, and also because of the retaliation. So it's discrimination and retaliation in these circumstances. So who's not covered? Who are the employees that aren't covered? Well, we talked about the possibility of an owner not being covered in the case of a partner. We've talked about when you are an employee of an entity that has fewer than 15 employees. Also, non-U.S. citizens who are employed outside of the United States by a U.S. company, those aren't covered. So let me give you an example. Let's say that Walmart opens a store in Mexico, and it hires a Mexican citizen to be the store manager there. That Mexican citizen can certainly sue Walmart for a type of discrimination if something like that happens under Mexican law. But that Mexican national cannot sue Walmart under Title VII. But let's say also in that store, the assistant store manager is a U.S. citizen. So the U.S. citizen works for a U.S. company like Walmart in that distant country. We're saying Mexico, but it could be anywhere. In those circumstances, that U.S. citizen could sue Mexico under Title VII as long as the local laws do not expressly forbid the avoidance of discrimination, which obviously that would not be the case in Mexico. For this particular protection, Walmart would not be able to say, well, local custom here is blah, 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 blah. We had to follow local custom. Local custom is not the standard. That you have to, in order for Walmart to get out of complying with the law, it has to point to a particular statute that directly says, you know, women can't work in this industry, or people of this race can't do this, or whatever the particular thing is. So let's say I am a U.S. citizen and I decide to go work for Toyota in Japan. So I am a U.S. citizen, I'm not working in the United States, and I am employed by a foreign company. Under those circumstances, I may well have protections under Japanese law against employment discrimination, but I can't sue under Title VII. So that's how that all works. Another exception is when a business, not a business, but an entity is a religious entity. So a church, a mosque, a synagogue, or other place of worship, or a school, or another entity that is primarily involved in a religious message or a religious mission. Those entities, when they hire people to perform the religious activities, the ministerial exception applies. So let's imagine that I am a female who goes to a seminary program, and how about this? So I am Jewish, and I have gone to a rabbinical school and have gotten my credentials to be a rabbi. And I apply to become a rabbi in a ultra-Orthodox congregation that does not does not permit women to be rabbis. Well, then I'm obviously not hired, and then I might file an EOC charge against that particular synagogue. Well, the synagogue would be able to say, well, our ministerial exception permits us to, in a sense, discriminate against this candidate because of her gender, because our religious beliefs say women shouldn't have this role. Similarly, like the Catholic Church, who doesn't have women in the role of priests, would be able to turn down a woman who applied to become a priest. But it's not just those leadership roles. It could even be a school teacher in a private school for a private religious school. Now, a private school that doesn't have a religious mission wouldn't be able to discriminate, but the ministerial exception does permit when the employee is going to be involved in the religious duties. Now, let's imagine that I'm being hired to be the janitor in that synagogue or that religious school. Well, being a janitor doesn't involve a religious duty, and so the synagogue wouldn't be able to prefer a person of a particular religion or particular age or race. They would be required to hire the most qualified person. Another category that's different or that doesn't apply is Native American employees working around a Native American reservation. Under those circumstances, it is permissible to prefer the Native Americans. One thing, though, the law prohibits is that the employer can't prefer one tribe over another tribe. So if I'm a Native American and I'm a Shawnee, and maybe the local Native American reservation is Muskogee tribe, the Muskogee, let's say, and I apply to work for the local employer there, and they want to hire Muskogee Indians, not Shawnee Indians. Well, under those circumstances, they'd be violating the law. But let's say that there's a third candidate, and that candidate is African American or white or Asian. Well, it'd be perfectly fine for that employee under those circumstances, or for that employer under those circumstances, to prefer the Native American. So let's go through a few scenarios. So Mary has been employed in the London office. She's a U.S. citizen. This company is a U.S. corporation. She's recently laid off. She thinks it's because of her gender. So because she's a U.S. citizen and her employer is a U.S. citizen, even though she was working in a foreign country, she can sue under Title VII. Now Mary, different Mary, obviously, she's not a U.S. citizen, but she works for a U.S. corporation. She's still based in London. She's terminated for her job. She thinks it's because of her gender. But guess what? Because she's not a U.S. citizen, even though the company is a U.S. corporation, she can't successfully sue because her job was not in the United States. Now, if it had been the United States, if we changed London to, say, Atlanta, then yes, of course she can successfully sue. Okay, so Bob studied voice, opera, and Jewish liturgical music at a seminary. He graduates and he applies for a job as a cantor, which is the person who sings during a Sabbath a worship service. And so he's got a very skillful voice. He knows exactly how the music is supposed to be sung during a Sabbath presentation. And so he applies for a job at a synagogue in Plano. The synagogue says, no, thank you, Bob, because you, in fact, aren't Jewish. We'll say Bob is a Baptist. Bob files a charge of discrimination, and guess what? The synagogue is not required to hire Bob because this is because of the ministerial exception. I think I already covered these. Let's look at our scenario. Mary owns and operates an inn near an Indian reservation. She favors Indians when hiring for positions in the inn. That's perfectly fine. What she can't do is favor Lumbee Indians over Cherokee Indians in her employment. It's not necessary that Mary herself be Indian or Native American. So let's talk about the statute of limitations. We've talked about this before, but it's really, really important because the statutory period under most discrimination statutes is very, very small. So let's first of all think about if you work for the federal government. You have only 45 days to complain about the discriminatory event. It's barely happened and you have to file a charge. You may still be processing it. If you're a government employee, maybe a state government employee, you have 180 days. I mean, that's more, but it's still only 6 months. Most statutes are quite a bit longer than that. Now, there is an extension to that. Most employees actually in the United States have 300 days. The reason that they have 300 days instead of 180 days is because of FEPs. It's going to let me do this. It's going to let me, no, it's not going to let me right here. Okay. FEPs, an FEP is a Fair Employment Practices Agency. Many states have these, including Texas. And if a state has one of these, there's a work share agreement between the EOC and the FEP or the 504 agency. Synonymous terms for that. And so in those states that have the FEPs, the period of time that you can have to file the charge is actually 300 days instead of 180. Now, as you can see, because of the short statutory period, it's not unusual to have a plaintiff who's just missed the date. They didn't really get that time was of the essence. They maybe thought, well, surely I've got a year or two before I need to file this. And when they realize they don't, it's too late. Is that plaintiff out of luck? Well, sometimes he or she is, but not always, because there's those statutes we talked about before. Remember I said before how Section 1981 has unlimited damages, and that's a big benefit. But there's another really big benefit, sometimes it's even more important, is that there is a 4-year statutory period. So instead of 180 days or 300 days, the plaintiff has 4 years. And so that kind of helps a delayed plaintiff when acting. Now, of course, the Section 1981 only applies in race cases. It doesn't apply, for example, in gender or religion cases. So it doesn't help in every circumstance. This is another important case. I think I mentioned it before, so I'm not going to do a deep dive into it this time. But the Lilly Ledbetter Fair Pay Act of 2009 was the direct result of a decision that the U.S. Supreme Court made, which said that it established a statutory period. In this case, when Lilly started to work for her employer a long, long time ago, on that first day they established a pay rate that was perhaps discriminatory. At least that was Lilly's allegation. But she didn't find out about it for years and years, decades passed. And so it was her position, well, or there was her employer's position, hey, you only had 180 days or 300 days to file, and gosh, that's passed a long, long time ago, so you waited too late to file. Well, Lily's position was, well, each time I got a paycheck, I was being harmed again by that bad pay that I was initially established, because that first pay set me up for a certain type of increase throughout my career. And so if I had been paid more at the beginning, I would have ultimately reached a higher pay rate. And so each time I received a paycheck, there was another violation. So I ought to be able to go back at least the 180 days from the date I filed my charge. And so while I'm not going to get all of the money back to my first date of employment, at least I'll be eligible for some. And that was what the case was about. The U.S. Supreme Court disagreed with Lilly Ledbetter and agreed with the employer, but of course Congress said, no, we don't agree with the U.S. Supreme Court. We agree with Lilly. We think she ought to be eligible for at least a portion of that back pay. And so that's how we got the Lilly Ledbetter Act. And so this is a summary of what the law provides. The 180-day statute of limitations, we could also say the 300, which is more likely to be the case, with regard to wage discrimination begins to run all over again each time a paycheck is issued based upon pay discrimination. Here's some vocabulary terms. When a person files a charge of discrimination, we call that person either a claimant or a charging party. I have more commonly heard charging party than claimant. Obviously, both terms make sense because we call the document filed the charge of discrimination. And certainly the claimant is filing a claim. So either term will work. People will understand what you're saying, but I might say charging party is the more common. Respondent is the employer. So obviously this is going to be the employee or the applicant or the former employee. The respondent is going to be the employer. This is the person who supposedly violated Title VII. And again, typically they're called respondent, but they could be called responding party. Sometimes even people will call them the defendant. That's a little premature though, because a lawsuit hasn't been filed when you're dealing with the EOC. So usually terms plaintiff and defendant aren't appropriate. Of course, the EOC will assign the case to a particular investigator. And if you have an interest in this, with the type of training you're learning in this class, you would be well positioned to be considered for such a position. We do have an EEOC office in the Dallas area. It's in downtown Dallas. And so that could definitely be a career path for you to pursue. This is somebody who investigates the claims that claimants file. And the investigator obviously listens to what the claimant says, listens to what the respondent says, reviews the documents, interviews witnesses, and reaches a conclusion. Let's talk about posters and record keeping. An employer is required to put up posters where both applicants and current employees will routinely see a description of their rights under these statutes. Sometimes the posters can be in just one location because that's where applicants might be and that's also where employees might be. Sometimes they're in different locations. For example, you might choose to have the posters in the employee locker room or the employee break room, but you don't necessarily want your applicants in those areas. So these posters can be lots of different poster formats. For example, you can, if you want to save a little money, you can go to each one of the websites for all the various statutes and print out what the posters are going to look like and post those on the wall. It's very common for employers, especially larger employers, though, to buy what are called all-in-one posters. And typically, an employer is going to need to have two all-in-one posters. One is a federal all-in-one posters, which lists all the legally required notices that are required under federal law. For example, OSHA, Title VII, ADA, ADEA, Polygraph Protection Act, all those statutes will be put into one pretty darn big poster with pretty small print. And that, of course, needs to be displayed. And then there would be also the equivalent of the state poster. Obviously, that's going to vary from state to state what protections exist. And then, of course, you would need that to be present where the applicant is. If you accept online applications, then you would need to have those poster information available to candidates or applicants who post their or apply online. So what happens if an employer doesn't have the right posters up or something along those lines? Well, that's a violation of the statute even if the employer didn't actually discriminate. It's pretty rare that an employer is penalized for that, for failing to make the posters if there hasn't actually been a provable act of discrimination. But if there has been an act of discrimination, the jury is going to hear about the failure of the employer to put the posters, and that could point to the motivation. After all, maybe the employer didn't put the posters because the employer didn't want the employees to know what their rights were under those particular statutes. So it's a bad fact for the employer. Sometimes, though, posters aren't updated people forget to put up a new poster when the law changes or additional protections come down the pike. So if you are working as an HR manager, you want to make sure that those posters are maintained and kept up to date, and that you are making sure that when people move posters around, they put those back up in the place they need to be. There's also certain record-keeping requirements that HR needs to do. One of those is the EEO-1 report that is sent to the EEOC every year, documenting the mix of employees, both the various positions they have and ethnic and gender aspects to those employees, another important responsibility. This is that case that we talked about, or the decision that caused Title VII to be considered constitutional. It actually wasn't an employment law case. This was a hotel in Atlanta called the Heart of Atlanta, and it did not want to permit African Americans to stay in the hotel. And so it was challenging the public accommodations portions of the Civil Rights Act of 1964. But the U.S. Supreme Court said, nope, the statute is lawful. The power under the Commerce Clause is broad enough that it includes that right of Congress to pass a law along these lines. So this has significance certainly to us with respect to Title VII, but it also has broader implications for our whole economy and to the power that the federal government has in managing economic relationships. Okay, so let's talk about some amendments that happened. We've gotten us up to the point where we've passed the law, we've had it be held we've had it to be held constitutional, and that happened again the same year that the law was passed. But as oftentimes happens with important laws, there were some tweaks. People started thinking, hey, why didn't we add this to it? Or now that we've tested it out and it seems to be working okay, maybe we want to broaden it. So it was extended to employees, and then it was extended to pregnant women. Or I guess you might say, well, gosh, weren't women already included? Because we said gender, so wouldn't pregnancy have already been included? Well, that wasn't how it was interpreted at that time. Certainly only one gender can be pregnant, clearly, but the and so it wasn't interpreted, though, that because a woman gets pregnant, therefore she can't be terminated. It used to be the case that women would be fired. Some women, under certain circumstances, would be fired if they got pregnant, and the employer was not violating the law by doing so. So this statute was an amendment to Title VII. It passed in 1978, and it said an employer can't discriminate against women because of their pregnancy or related conditions. So a woman who is recovering from childbirth, for example, or a woman who's experienced a miscarriage cannot be adversely affected because of that. The one thing, though, the Pregnancy Discrimination Act doesn't do is it isn't a type of reasonable accommodation statute. So let's say that I am pregnant and I have some complications and I need to be on bed rest for a period of time. Well, under this statute, it would have been perfectly fine for my employer to dismiss me because there was no Family and Medical Leave Act type leave that was guaranteed to me under the Pregnancy Discrimination Act. What the law provides is that the employer has to give the same type of benefits to a pregnant woman that it would give to another worker who was experiencing a health condition. So it did not have to prefer pregnancy over other health conditions, but it couldn't treat the woman less advantageously. And so it's not an example of a reasonable accommodation, but it is kind of maybe the beginning of going down that road. We already talked about race norming in previous lectures. One of the things that the Civil Rights Act of 1991, it did lots of things. It amended Title VII in lots of respect. It also amended Section 1981. One of the things it did under Title VII, though, is that it said to, and by the way, Civil Rights Act of 1991 was generally a pro-employee statute. But one aspect that some might argue that was less pro-employee was that it prohibited race norming. It did not permit employers to do that. So if an employer wanted to do that, the employer was prohibited. And certainly an employer who didn't want to do that would not be required to do that. So imagine that there was a test that a particular employer implemented, and the statistics indicated that a particular gender or a particular race or a particular religion, employees of a particular religion tended to score less well on it than others. Well, the employer would be prohibited from allowing a lower pass rate for those particular scores under those circumstances. Unfortunately, oftentimes because of a lack of educational opportunities, some people of differing ethnic backgrounds and racial backgrounds have more difficulty being successful on testing tools that people who have a more academic background are able to perform better. These differences in testing ability do not necessarily reflect differences in performance ability. And so the idea was, well, if we corrected for the lack of test-taking experience or educational background, then we wouldn't be undermining the effectiveness of the testing product. But again, the Congress said, no, that's unlawful. It would be reverse discrimination if you allowed, say, African Americans to have a lower pass score than, say, Asian Americans. Okay, so let's talk about some laws that happened after Title VII. So we've talked about the Equal Pay Act, we've talked about Title VII, and we talked about some amendments to Title VII, including the Pregnancy Discrimination Act. Discrimination didn't end in 1964. It certainly was a very important step along those lines, but discrimination continues in employment, and it continues to be an issue. It probably is significantly less, at least amongst many groups, but that doesn't mean that it's gone away. In fact, one of the things that happened as part of the Civil Rights Act of 1981 is that a glass ceiling commission was implemented, and it was designed to investigate why African Americans and other minorities and women seem to have difficulty rising to the most high levels within corporations. Not non-white people and non-men, I guess women is what I should call that category, sometimes can make it to middle management, but getting beyond that level, there seems to be some hurdles. And so that was the call of the commission. And again, those hurdles can still continue to exist today, even though this commission was implemented in 1991. They have not fully addressed all these issues. So we've talked about Title VII, we talked about the Equal Pay Act. Actually, it would have been better if I'd put this one on top, wouldn't it? We've talked about the Pregnancy Discrimination Act, which was an amendment to Title VII, but we also have the Age Discrimination in Employment Act, ADEA, and we have the Rehabilitation Act, and that is very similar to the Americans with Disabilities Act. The Rehabilitation Act was a statute that required governmental entities to not to discriminate against people with disabilities and to provide some reasonable accommodations. Once this law proved to be helpful and doable, then it was extended to the private sector through the Americans with Disabilities Act. So we'll talk more about many of these laws in subsequent lectures. Again, here's a little bit of a breakdown with respect to that. More specifics about these various laws. Oh, we also have USERRA is what this law is typically called, the Uniform Services Employment and Re-Employment Rights Act. We'll talk about this in more detail. This is probably, honestly, the most surprising of the laws. As you go through this class, you'll see that there's a lot of similarities between these laws, and you might kind of say, okay, I kind of know what to expect. Maybe I don't know a lot about this statute, but I see patterns. Well, this statute really kind of blows that pattern idea out of the water. It doesn't fit the patterns that we'll see in other situations. And then our most recent statute is GINA, which is the Genetic Information Non-Discrimination Act. It hasn't yet had a lot of teeth to it, but who knows what the future holds with medical advances, our ability to find out what's in our genome, that may well change. Okay, so we've talked about what the federal law protects us from, but let's talk about some things it doesn't protect us from. One is it doesn't protect us from marital status discrimination. So if I am, uh, say, single and my employer doesn't wants married people, well, that's lawful. If I'm divorced and my employer doesn't want divorced people, it's lawful. If I'm widowed and my employer doesn't want widowed people, that's lawful. If I am living with somebody without benefit of marriage, then the employer is free to not want me to be their employee under those circumstances. So marital status is not covered under federal law. Sexual orientation is also not a protected category under federal law. This is very surprising to many people, especially since we now have same-sex marriage in the United States, because the finding that there was a constitutional right to marriage, even for people who have a same-sex orientation or same-sex attraction orientation. But there is no employment discrimination protection on a national basis. Now, I say that, but Title VII does not explicitly cover sexual orientation. Some courts have said, well, we ought to reinterpret the term gender to cover gender identity and sexual orientation. So far, that has not been successful in front of the U.S. Supreme Court, and it hasn't been successful in the Fifth Circuit, which is this appellate court that covers the state of Texas, Louisiana, and Mississippi. It, though, could in the future be expanded. So, but right now, our understanding, at least in this part of the country, is that federal law does not protect us from sexual orientation discrimination or from gender identity discrimination. We'll talk more about both these topics later on. When I use the term gender identity, what I'm talking about is somebody who has a gender identity that's different than the one that they were identified as at the time of their birth. So, for example, somebody who may have a birth certificate that indicates they're female, but they self-identify today as male, or vice versa. That would be a gender identity issue. And as I say, currently under federal law, that's not a protected category. Although the EOC maintains that both sexual orientation and gender identity discrimination are covered by Title VII under the term gender. So again, there's a little bit of fluidity here, but for the purposes of this class at this time, you should assume that sexual orientation and gender identity are not covered by Title VII. Some states also provide protection for people based upon their tobacco and alcohol use. So let's say that it's not unusual for employers to say, if you use tobacco products, you'll have to pay an additional benefits fee on your health insurance, for example. Or you can't work for us if you use tobacco, or perhaps even alcohol under those circumstances. So some states have laws that say, well, employers can't regulate that. Other categories can be nepotism rules or relationships outside of work. So an employer can't for example, prohibit employees from dating outside of work, or dating each other outside of work, or that type of thing. None of these categories are protected in Texas, and I don't think it's likely that in the future they will be protected. Employers have generally a fair amount of liberty to design their employment structure the way that they would like for them to be. Having said that, it doesn't mean that these types of restrictions are a good idea. It's just that they are not an unlawful idea. As an HR professional or a paralegal or an attorney, this doesn't mean that you ought to recommend to your employer that they discriminate against people under these categories. It just means that it's lawful if the employer chooses to do so. So I want to make clear that this isn't a policy recommendation, it's just the nature of the law. Okay, Family Medical Leave Act, we talked a little bit about that. This was passed, again, right after the Civil Rights Act of 1991, obviously. And it is a different type of statute than what we've seen up to now. This puts burdens on employers. It's kind of like the reasonable accommodation provisions under the Title VII for religion and under the Americans with Disabilities Act. But this doesn't limit the categories to religion or disability. Really, any employee is potentially eligible for the protections afforded by the Family Medical Leave Act. This law gives covered employees up to 12 weeks of unpaid leave to take care of family and medical issues. For example, the birth or adoption of a child, their own serious health condition, or the serious health condition of a close family member. It's a very complicated statute, and we'll talk more about it as we go forward. Already kind of mentioned you, Sarah. This is a statute that protects veterans and active service members. They receive some pretty neat benefits upon their return from their active duty assignment. And so, again, it's a very generous very generous statute for veterans when they return to their private sector work. Okay, so let's talk about the types of employment discrimination. We've kind of already covered these, so I'm not going to do a very deep dive. I'm going to refer you to the earlier video where we talked about disparate treatment, disparate impact, and mixed motive we're not going to focus on here, but also the idea of reasonable accommodation and retaliation. These are the buckets that we would look to. So let's talk about pretext. This is when the employer's stated reason for a decision isn't the real one. It's a fib, in other words. So let's say that Bob's manager wants to fire Bob because Bob is a Jehovah's Witness, and the manager just doesn't like Jehovah's Witnesses. And so the manager isn't going to say to Bob, or probably isn't going to say to Bob, Bob, I'm firing you because you're a Jehovah's Witness. Just not going to do that. He's more savvy than that. So he'll be looking for something in Bob's performance that he can identify as a reason to fire Bob. And let's face it, none of us are perfect at work. Maybe we send a personal email. Maybe we show up 5 minutes too late, work too late. Maybe we miss a deadline. We're probably going to do something wrong. And if somebody's looking over our shoulder every minute, they'll find it. So eventually Bob's manager observes that Bob sometimes comes to work late. And so he says, I've got it. I'm going to fire Bob for tardiness. And in fact, Bob really was tardy. So the manager isn't lying when he says, I'm going to fire Bob because he was tardy, because in fact, there were tardies. But the real reason was because of the religion. So Bob might be able to show, well, Sally, who's a Presbyterian, and George, who's a Buddhist, they had tardies as well, and yet they were not dismissed. And so that would tend to show that the reason that Bob's supervisor fired Bob is really a pretext. It's not a lie in the sense that the behavior happened, but it's not the real reason behind the adverse employment action. Oh yeah, we just think about mixed motives. Mixed motives, in that case, the employee has to prove that the discrimination would have happened but for the illegal motive. So let's imagine this scenario. Let's say that the employer, we'll go back to the Bob scenario. Bob's a Jehovah's Witness. The employer just hates Jehovah's Witnesses. But you know what? Bob really is tardy to work pretty often. And this employer has consistently fired employees who've had 5 tardies in any 6-month period. And guess what? Bob had 5 tardies in a 6-month period. But also this supervisor had told Bob several times, I can't stand Jehovah's Witnesses. I find them offensive and I don't like to be around them. So this would be a classic mixed motive situation. There seems to be 2 reasons why the employer is trying to get rid of Bob. Number 1, the legitimate reason, the tardies. The second reason, Bob's religion, an illegal reason. So what Bob is going to have to show is that even if we if we didn't have the religious animus, he wouldn't have been fired. if he had merely had the 5 tardies in the 6 months, but he had been a Presbyterian, the employer would have said, "Oh, Bob, come to work more reliably, but you can still stay here." That Bob would have to show that it really was the Jehovah's Witness part that was what sank him. But if the employer can show, well, gosh, every single employee who has had 5 tardies in 6 months, we fired. Here's, Teresa, who's an atheist, and Sally, who's a Baptist, and, Peter, who's a Jewish, and, all the way through. And all of them who have over 5 or more were terminated, then it's going to be very difficult for that employee to win that mixed motive case because of the but-for rationale. We're not going to talk about harassment because we'll talk about that later on, but just be aware harassment and retaliation or other claims. I'm not going to go through the prima facie case material for the most part. That's something we've covered in other modules. I like to keep on showing it though because the prima facie case standard applies everywhere throughout this material discrimination. There's a judgment call that you have to make if you're teaching a course like this because certain topics come up again and again and again. I mean, whenever we talk about race discrimination, you want to talk about prima facie case, but that also applies in gender discrimination and religious discrimination and disability discrimination. And so we could talk about it 20 times, or we could talk about it really thoroughly once and then just passingly refer to it. But I'm just going to make a comment about it here. Just keep in mind that if you need a refresher, the material is available here. I do want to point out, though, that after the plaintiff makes the prima facie case, then the burden goes to the defendant. Remember that 3-point thing? Prima facie case is step 1. Defendant has the opportunity to produce evidence of a lawful motive. Again, going back to the example of Bob, that lawful motive was all the tardies. And then step 3 is the rebuttal, where the plaintiff can come back and say, "Oh no, you say that's the reason, but I can show you it's not because look at Samantha. Samantha had 6 tardies and she's still employed, and she's Episcopalian." So we've talked about prima facie case just a little bit. That is what was called circumstantial evidence. But sometimes there's that smoking gun evidence, that direct evidence. An example of that would be those comments that Bob heard about his religion. Or it could be racial epithets, or it could be other things along those lines which seem to show direct evidence of discrimination. That evidence can also be used to show disparate treatment. So the plaintiff isn't stuck with the prima facie case model. He also can use the direct evidence model. We talked about cat's paw theory earlier. Sometimes you can have a decision maker who really isn't trying to discriminate, but he gets incorrect or at least clouded or distorted evidence from somebody who is a discriminator. And so the decision maker bases a decision upon evidence that is flawed. Well, it's not really relevant in that case what the character of the decision maker is. It's more relevant what the character of the person who gave the tainted data. And so that's called a subordinate bias theory or a cat's paw theory. And this is a valid way to approach it. So if you're the plaintiff, you can approach it from, yes, the person who made the decision is discriminating, if you've got those facts. But if you don't have those facts, you can then point to, well, who did he get this data from? Maybe that person is the discriminator. And that is a valid theory as well. Already talked about prima facie case. We talked about disparate impact earlier, so I'm not going to go over that. Retaliation, this is again another theory. Retaliation can happen. A person who has actually been the victim of discrimination, or at least thinks he's been the victim of discrimination, and who complains about it can have a retaliation claim. But also a bystander, somebody who does not himself think he was the victim of discrimination, but who reports action against somebody else who he thinks was the victim of discrimination, or if he testifies on behalf of that person, that type of behavior can open up the possibility of retaliation and therefore a retaliation claim. So retaliation focuses upon the employee's protected activity rather the employee's protected class characteristics. So going back to my story of Bob, Bob overhears a supervisor say, Jehovah's Witnesses are the worst people ever, da 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 da. Well, in addition to Bob hearing this, Bob shares a cubicle with Mary. Mary, who isn't a Jehovah's Witness, overhears the same vitriolic statements made by the supervisor. Ultimately, Bob loses his job. He files a lawsuit. Mary is called to testify. Mary testifies truthfully. Yes, I heard the supervisor say terrible things about Jehovah's Witnesses to Bob. And so certainly that testimony is going to hurt the employer with respect to this lawsuit. Well, let's say the employer turns around and fires Mary for making this testimony, or at least that's what Mary's belief is. Mary would have a good retaliation claim, even though she herself is not a Jehovah's Witness. And again, the retaliation claim prima facie case would be that not so much that the plaintiff was in a protected category, but that she engaged in protected activity, oppositional activity. But then the other things are going to be the same. Step 2 is going to be the same. Step 3 is going to be the same as we saw in other retaliation claims. So let's talk about the process for a discrimination claim. We've talked about this a little bit, but let's do a bit deeper dive. So an employee feels that he or she has been the victim of discrimination. The first thing that he or she should do is file a charge of discrimination with the EOC or the state agency, the FEP. In Dallas, almost certainly the employee will file with the EOC because the FEP we have is the Texas part of the Workforce Commission, and its office is in Austin. It only has one office, so you can see how that's not very practical to interact, whereas the EOC's office is in Dallas. So most likely, if you confront these issues locally, you will be dealing with the EOC. And the reason why the employee is going to go to the EOC is because the employee under most of these statutes, including Title VII, will have the obligation to go to the agency before they have the right to file a lawsuit. They have to exhaust or use up all of the administrative remedies available to them under Title VII, which means they have to complete the EOC process. But under that Section 1981 and Section 1983, those post-Civil War statutes, there was no EOC, so there obviously was no requirement that the plaintiff exhaust administrative remedies. So under those statutes, the employee can go ahead directly to court, doesn't have to wait for the EOC to complete the case. So it's a little bit quicker remedy. That's another one of the advantages to the post-Civil War statutes. And again, those are only going to be available based upon race, not upon religion or disability or age or gender. So for folks it applies to, for plaintiffs it applies to, it can be a useful tool for them. Okay, so we already talked about the 180-day to 300-day filing period. Again, in Texas, it's going to be the 300-day. The agency is the 706 agency, or it's the FEP agency. Either one is fine. Let's go to the next one. Already talked about that one. Once the charge is filed, the investigator who assigned to the charge will send it to the employer and ask the employer to respond to the allegations. The investigator will probably ask specific questions about the allegations, maybe ask for some comparative data from the employer. In addition, the investigator will likely invite both parties to a mediation. The mediation process in the EOC is free. I hate to be jaded here when I say this, but you get what you pay for. I've never had a mediation through the EOC that was the type that was likely to be successful. Part of it is because it's free. When something's free, people who are participating in it may not take it as seriously. The parties don't have to agree to a mediation, and in fact, many times they won't agree. Usually the employer is the one who doesn't, primarily because the employer realizes it's kind of a waste of time, whereas typically the employee doesn't have that background of experience with these matters, so they're not in a position to know that it's not as productive. Of course, there is the anti-retaliation provisions. So if that employee's filed a charge is still an employee, you have to be really, really careful about how you manage that employee. Again, I hate to sound jaded because many discrimination claims are very, very valid, and many retaliation claims are very, very valid. But there have been cases, certainly, where employees kind of knew they were on the slippery slope out the door. Maybe they were put on some kind of disciplinary action, or they knew the layoffs were about to happen and they thought to themselves, well, maybe I can buy myself a little job security, file a charge of discrimination, because my employer will be reluctant to fire me if I have one of those pending, because my employer won't want to face a retaliation claim. So there can be some almost, I'm going to call it an offensive as opposed to a defensive use of an EEOC charge. If mediation doesn't work or one of the parties decides not to participate in it, then the EOC will start the investigation process. The investigation process in theory ought to be done in 6 months, but I've definitely seen cases where it's extended longer than that. In a different state, when I was dealing with a state agency, the investigation lasted 5 years. It's kind of a ridiculous situation. The facts of those cases were pretty thin. There really was no need for it to extend very long at all. But during that time, unfortunately for the plaintiff, she wasn't able to file her lawsuit. She didn't have good facts, so she never would have been successful, but she was kind of in a holding pattern during the time. And so it really wasn't a very fair situation for either the employer or the employee. If the parties agree to mediation and use the EOC process, then the mediator assists the parties in the effort to settle the case. Now, this is a voluntary process. The mediator can't force either side to agree to any particular terms. But if the parties do reach an agreement, the agreement would be binding. So that would be the arrangement between the parties. So let's say that the mediation doesn't go forward or isn't successful, and so the case is going to be investigated. The EOC does conduct the investigation, and the investigator makes a recommendation through the EOC process of either a probable cause or a no probable cause finding. Assuming that that recommendation is approved, it is then sent to the employee with a CC to the employer. The vast majority of cases result in a no probable cause finding. What I found most recently was a 61%. I was actually kind of surprised by that. My experience at JCPenney was that it was more like a 95 or higher percent a chance of a no probable cause finding. My guess is my experience at JCPenney were a little bit misleading because larger employers have more checks in their system, and so it's less likely that there would be irregularities in the making of employment decisions. Also, JCPenney was, in my opinion, a very good and ethical employer, and so there was less likely to be those types of actions. No employer is perfect, but on the continuum, they were definitely on the good side. And smaller employers, maybe less ethical employers, probably drag down that average a bit. Still, I think 64 is a little bit on the low side. I wouldn't be surprised if that number is actually somewhat higher. Hopefully, wherever you work or support, either as a paralegal or as a HR manager, you'll have a higher rate than 64. So what happens? What does it mean that you get a no probable cause finding or a probable cause finding? Honestly, it means very little. If you have a no probable cause finding, you have 90 days to file your lawsuit. Okay. If you have a probable cause finding, you have 90 days to file your lawsuit. Your probable cause finding or your no probable cause finding will not be admissible in evidence. The jury will never know either way. So you might say, who cares? Well, there is some benefit to having a probable cause finding. One thing is that you're probably, as a plaintiff, going to find it easier to hire an attorney. If you take this to an employment plaintiff side, employment attorney with a probable cause finding, that attorney is going to say, these aren't common. That doesn't guarantee that he or she will take the case, but it certainly would be a good fact. Now, if you have a no probable cause finding, I don't think it means that you couldn't hire an attorney, because as I say, in the majority of cases, there is going to be a no probable cause finding. So I think most plaintiffs' attorneys are open to hearing why they ought to consider taking the case. But certainly it does help get that, perhaps getting the attorney arranged. Certainly, a plaintiff can, or excuse me, a charging party can have already hired an attorney before the probable cause finding or no probable cause finding. In fact, that's the best practice, because once you get the finding, you only have 90 days to find that particular attorney and to file the lawsuit. That's a pretty limited amount of time to accomplish those tasks. Also, during the investigation, having the representation of an attorney can help the plaintiff tremendously in being more effective, making it more likely that you would get a probable cause finding. And also, the plaintiff can, or excuse me, the charging party through the attorney can make requests to the EOC that are advantageous for the advancement of the case. But as a practical matter, in most cases, the charging party isn't going to be able to secure an attorney or isn't going to know to do that. So, the document that accompanies the probable cause or no probable cause finding, or is actually part of the same document, is what's called the right to sue letter. It's again given to the claimant saying, you have the right to sue. We didn't find anything, but you can still go ahead and sue. But you have 90 days from the date that you received this letter. Now, I said that the EOC could issue a probable cause finding or a no probable cause finding, and that is what happens 99% of the time, probably even more than that. But there is another thing that the EOC can do, and that would involve the EOC saying, you can't sue after all, because we're going to sue on your behalf. Now, you might think to yourself, oh, this has got to be great news for the plaintiff, right? He doesn't have to worry about finding an attorney. He can just let the government do it for him. And the government's going to have to pay all the bills. So this is a wonderful outcome. Probably there are times where that is exactly what the result is, and it's good news for the plaintiff. But in many cases, it's not good news. When the EOC chooses to sue on behalf of the employee doesn't get a vote. The employee now is going to be essentially represented by the EOC. The employee can have his own attorney, but that attorney doesn't have the power to force the EOC to settle the claim. The reason that it's probably not something that the employee is going to be too happy about is that the EOC's agenda is not identical to the employee's. Think about it. You're an employee, you were terminated from your job. You are living off of your unemployment, if you've awarded unemployment, or off of your savings, or maybe you're living on your mom's couch. Things are not good for you. This is not a happy situation. What do you want from your employer? Well, you want money. That's what you want. You may want reinstatement, but really you've got real financial needs, and that is what makes you happy. You want money. Your employer probably doesn't want to give you money, but if you've got good enough facts, perhaps, quite likely, the employer will be willing to negotiate some type of settlement with you. If it's just you suing the employer, you can probably work out a deal, at least most of the time, if you've got pretty good facts. But if the EOC is involved in it, the EOC will say, well, you can't settle anything unless we're in it. And we aren't going to be willing to sign off on this because we care about you getting your money. We want you to get your money. We're not against that. But what we really want to do is make this employer be a better employer. We want the employer not to discriminate against you, but we also want this employer not to discriminate against people in the future. So we want to require the employer implement a training program to avoid this problem in the future. We also want to be able to use this settlement to our kind of almost marketing advantage. So we can get it in the newspaper so people will be more educated about employment discrimination. They'll know about our function, they'll know where to find us. And so we'll be able to use the press in that way. Well, think about if you're the employer. Do you want on the front page of the Dallas Morning News, EOC gets settlement from, Blah, blah, blah company? No, of course not. That is a very negative implication. You were willing to settle with this guy when it was just going to be a private deal. You were going to have a confidentiality provision the press was never going to know about. The press didn't even care about it. But now it's going to be front page, or maybe not front page, but at least a matter of some general knowledge. And so the opportunity to settle the case has dramatically declined. As a result, you're almost certainly going to go to trial. And that means there's going to be a lot of delay, and trial is always risky. You might get a significant amount of money, you might not. So the third option is the EOC can sue on behalf of the employee. But no matter, again, what the EOC decides, the charging party always can file a lawsuit. And of course, if the charging party can't find an attorney, the charging party can file what's called pro se, P-R-O space S-E. That means by himself or by herself. He or she would essentially be his or her own attorney under those circumstances. So let's consider a scenario. The EOC has investigated Bob's complaint and has found that there is no probable cause for Bob's complaint. So the right to sue letter issues. Bob gets the letter on we'll say October 1st. From October 1st, he has 90 days. So basically until the very end of December to file his lawsuit. If he misses that date, then he will not be eligible to pursue his claims in federal court. Okay, so Bob did meet the deadline. He has filed his lawsuit, and now he is in federal court. The court there isn't going to give any type of consideration to what the EOC did. It's what's called de novo review. It's completely starting from scratch. Now, obviously, all the evidence that the EOC reviewed will be reviewed by the jury and the judge in this case, but the jury will never know what the EOC does. The judge probably will know, but the judge won't give it any deference. So it's not significant from that perspective. The EOC does have a very high success rate when it does litigate, but again, it gets to cherry pick the cases. It's only going to pick the cases, obviously, that have the very, very best facts. I mean, obviously, any law firm would do likewise, because the EOC gets to see virtually all of the cases of employment discrimination. It has a relatively small litigation staff, so it can only litigate a very small percentage of cases, and so obviously it's going to pick the best, and therefore its success rate is not surprising under those circumstances. Let's talk a little bit about arbitration. Arbitration provisions, arbitration agreements are fairly common amongst large employers and their employees. Not every large employer uses them, and even employers who use it don't necessarily use it with respect to all of its employees. In some jurisdictions, these are not always enforceable, especially if they include rather lopsided advantages for the employer. Texas, though, is a very arbitration-friendly state, and so these are going to generally be enforceable in Texas. And so if your organization has a arbitration agreement that it requires its employees to sign, and a particular employee declines to sign it and that employee is terminated, that almost certainly is going to be lawful in Texas. So what happens in the situation where Bob has signed an arbitration agreement, he is terminated, he files a discrimination claim with the EOC, the EOC finds probable cause and decides to litigate on Bob's behalf. Well, does that arbitration clause kick in? Well, it definitely would have kicked in if the EOC had issued a right to sue letter and Bob was going to have to find his own counsel. Well, then Bob would have to use the arbitration process instead of the federal courts. But if the EOC elects to sue on Bob's behalf, the EOC is not required to go into the arbitration. In fact, the EOC won't. It will be in federal court. And the case will proceed because, of course, the EOC never agreed to the arbitration provision. the remedies that Bob would be able to get through the federal court system will be limited. So even under those circumstances, it may be advantageous for Bob to go ahead and file the arbitration claim. But as I said before, it's very unusual for the EOC to actually file a lawsuit. So most of the time, the EOC's involvement isn't going to affect the enforceability of the arbitration provision. Let's look at a few scenarios here. So Bob is hired by Mary's Aquarium and he assigns an arbitration provision. He's fired, he thinks it's because of his religion, and he files a EEOC charge. The EOC thinks that his lawsuit is meritorious. The employer wants to have the lawsuit dismissed because of the arbitration provision. But of course, as we said before, no, the EOC is not a part of the arbitration provision, so therefore the lawsuit in federal court can absolutely go forward. Mary signs so we have another scenario. Mary signs an employment contract with her employer. Again, it also has a mandatory arbitration provision. She's denied a promotion. She files a charge with the EOC. But again, the EOC can pursue Mary's claims if the EOC can investigate Mary's claim. So this isn't even a lawsuit being filed. So even though no lawsuit is filed, the employer of Mary is going to have to follow the EOC investigative process, respond to the questions, do all that despite the existence of the arbitration agreement. Mary wishes to bring a racial discrimination lawsuit against her employer under Section 1991. There aren't any steps required before Mary may file her Section 1981 suit. Obviously, if there's an arbitration provision, that would also apply, so she would have to file her lawsuit. Instead of being a lawsuit, she'd have to file it through the arbitration mechanism if it's a Section 1981 claim. There are certain reports, mainly the EEO-1 report, that has to be filed by employers every year. Let's look at the Ali versus Mount Sinai Hospital case. In this case, the federal court granted summary judgment for the hospital because the claimant, Mr. Ali, failed to offer any evidence that the hospital enforced its dress code in a discriminatory manner. So again, you have to present some evidence to support your claims. The burden is going to be on that plaintiff to make the proof that's required. Generally, dress code claims are just not going to be successful. The plaintiff is going to have more. The idea that the court's going to have is, come on, buddy, just wear what you're supposed to wear. Come on, lady, wear what you're supposed to wear. Get over yourself. The only times that dress code cases typically are successful is when they offend the religious sensibilities of someone, or they have some health type of component to it. So for example, if I happen to be a Sikh and I wear a turban because I have my hair that is uncut, and my employer doesn't permit me to have my turban, well, that would be a violation of my religious beliefs. And so under those circumstances, I might be able to proceed with a dress code situation. Another example might be, let's say, according to my religion, obviously I'm a man in this scenario, I'm supposed to wear a beard. Or perhaps I'm an African American man and I have a skin condition that if I shave causes my beard hairs to become ingrown and can be very painful. And so an employer that prohibits me from having a beard or following that kind of a hygiene or dress code could be a violation. But if I don't happen to have that illness, or I don't happen to be of a religion that requires a beard, I just like having a beard, then that's I'm not going to be able to successfully advance that claim. As As always, your job as the HR manager or the paralegal is to make sure you document all of these issues. It's best practice to document always. None of us can do a perfect job all the time, so you want to focus on the cases that are more risky, but it's important to keep in mind that you don't always know which ones are going to end up being risky, and so err on the side of more rather than less. It's what's going to be your best way to remember what happened and your best way to convince that jury or the judge or the EOC that what you say happened is really what did happen, and the reasons that you say it happened are really the reasons that are true. So as always, you're going to want to make sure that your employees understand the requirements of Title VII and all the other laws. This is especially important for your supervisors and managers, but really all of your employees should understand that. And look for opportunities to train them, look for people to understand the negative implications and consequences for them when they don't comply with the law. Well, we're done with our presentation. It's been my pleasure to present this information. If you have any questions, don't hesitate to send me an email at cgroover@collin.edu or stop by my office hours, and I'll be glad to answer any questions that you have. Thank you for your attention, and I hope you have a wonderful day. Take care.